Okay, I can see those numbers going up, but we will make a start. As ever, there is lots to get through, and we've made it to December, everyone. Please do forgive the slightly festive attire. For those of you who put their decorations up thinking I've only just taken these down, surely, no, we have actually made it through 12 months of the year, and my goodness me, what a year it has been for employment law, for HR updates. So that's what I thought we would talk about today, is obviously what happened in 2025, blink and you miss it, and also have a little look ahead, little sneaky peek at 2026. But not saying too much because obviously we want to talk about that more when we get to January. But for those of you who are new to our Webinar Wednesday series, thank you very much and welcome. For those of you who've joined me since April and have joined every single one of our webinars, well done and thank you very much. Gold stars all round. The aim of Webinar Wednesday is really just to give those of you in HR, in leadership, and those of you who own your own business, an HR heads up, things to think about, maybe hearing from different people that you haven't heard from before, bringing you a different perspective, but always with an eye on keeping you one step ahead. And for those of you who don't know Doyle Clayton, we are a specialist workplace law firm based in the city in London. We have a Thames Valley presence and also a Bristol office. We support clients across the full broad spectrum of employing and engaging with workers and employees. We support lots of clients with litigation. In fact, we have a huge litigation calendar at the moment. There are certainly lots and lots of claims that are being brought, and I don't see that stopping when we think about the raft of changes which are coming next year and beyond. Also, we support clients with pensions advice, data protection and data privacy, lots and lots of DSARs at the moment. So again, if we can help with that, then please do let me know. Workplace investigations, again, lots of complaints, lots of issues being raised, particularly around harassment, sexual harassment, cultural issues there, historical issues. So again, supporting clients with either supporting them with their internal investigations or also conducting investigations on the client's behalf as well. And we also have an education team and a corporate team as well. So again, please do get in touch to find out more. For those of you who don't know me, I'm Emma O'Connor. I'm a partner here in our employment team at Doyle Clayton, and I also head up our client training services as well. And with that in mind, 2026 is looking very, very busy in the training calendar, which is fantastic. Really looking forward to working with you and your managers and HR teams in delivering training sessions, update sessions, not just legal, not just compliance, but also soft skills as well. So again, please do get in touch if you would like to run some sessions, whether in person, virtually, or pre-recorded as well. Lots and lots of options there when it comes to training. So please do get in touch with me. And as you know, Webinar Wednesday is a monthly affair, a monthly meetup, and next year we have a full calendar of monthly webinars for you to join or to listen again through our YouTube channel or our website. Again, lots of people coming, lots of people speaking to, again, bringing you that breadth and depth of information and knowledge. But January is going to be a look ahead, looking at HR trends, looking at things that we should have in our HR to-do list, and also looking at immigration as well. So again, please do join me on the 21st of January. Also listen to our podcasts. DC Talks just dropped a podcast, as they say, on free speech and academic freedoms on campus. So please do listen to that podcast. And we also have a new podcast, which is on our website now for you to listen to, but will be on Spotify and Buzzsprout and launched again on socials this week. And that is looking at the immigration changes. So again, please do listen to that and also subscribe and listen to some of our previous podcasts as well. And again, lots of podcasts in the diary for next year. Bit of housekeeping as always. Yes, we are live, but as you know, and as I've said, this is a high level overview. It's just giving you some tips, giving you some things to think about, things to have in your HR, on your HR to-do list and in your HR diaries. So it's no excuse for taking legal advice, particularly when I'm giving you some immigration tips as well. Please do get in touch for more advice because, as we know, immigration and employment law as well are incredibly nuanced based on the facts. So again, please do get in touch. So nothing's happening, is it? Quiet, all's quiet. Well, no, breaking yesterday. Who would have thought that Webinar Wednesday would be even more topical than it already is? Spoiler alert, fanfares, boxes of tissues, whichever you would prefer, but the Employment Rights Bill has passed. Drum roll, please. What this means is obviously the House of Lords did back down in the end. We were stuck, weren't we, in that fascinating game of parliamentary ping pong. Who would have known that that was a thing? And there was lots of speculation about whether the House of Lords would back down, lots of speculation about whether the House of Commons would be able to force this piece of legislation through. But in the end, the House of Lords decided to accept the concessions that had been made by government, and the last minute curveball that was thrown in by the government regarding compensation for unfair dismissal, which I will talk about in a moment. So not on the statute books yet. It still needs to go through and receive royal assent, but obviously there's going to be a really hard push on that, considering that the House of Commons and the House of Lords both go into recess tomorrow. So no pressure there. If obviously we get it through, it will become the Employment Rights Act 2025, not to be confused, of course, with the Employment Rights Act 1996. That's not going to become confusing at all, is it? So it has passed, it is coming, it is happening. We just need for it to have royal assent, whether we can get that through, whether government can get that through today or tomorrow, or whether we have to wait till January. But, you know, it's going to be challenging. Yes, there are opportunities, but I do think that at least now we can talk with some certainty, and you can have some certainty about what you need to do, what you need to be thinking about, because nobody likes the ifs, the buts, and the maybes. Now, obviously, we are still a little bit in if, buts, and maybe territory, because the Employment Rights Bill of itself needs help from secondary legislation in order to bring its intentions into being. And as we know, there is a timetable, a proposed timetable for implementation. So the first date for you will be April 2026, and I'll talk about what some of those changes might look like again in high level detail, because I want to be focusing a lot more on this next year. But again, I think it's worth just having a pre-Christmas, you know, think about it now and what we need to be doing and things we can start putting into motion. So yes, we know what is going to be within the bill, the act, obviously what it's going to be called. It's huge, it's massive, it's over 300 pages of itself. It's got lots of really strange sounding clauses in there, you know, with every single letter of the alphabet, because it is so big. But we have to wait and see what happens in terms of consultation. So expect a whole raft of consultation documents to be dropped now in December and also in the new year that we need to kind of keep on top of to understand the direction of travel. But at least we can talk with some certainty, particularly around the timetable. So key areas to watch, what's changed. I think the main one really that we need to be focusing on, and the key change is obviously around the unfair dismissal rights. And we saw that big U-turn back in November from the government. They were pushing, weren't they, for unfair dismissal to be a day one right. And this introduction of this modified procedure during an initial period of employment, which would have, of course, brought with it lots more challenges in terms of making sure we get processes right. The government U-turned on that, and now we know that from the 1st of January 2027, we will have a 6-month limitation period. So we will know that employees, once they hit that 6-month employment window, then they will reach that benefit of being able to bring the statutory right not to be unfairly dismissed. And that's huge, isn't it? It's going to make a massive difference. I was actually looking up when the period had been 6 months service, and it wasn't, we basically had it back in the 70s. So pretty much everyone now will not know what it's like to have such a short period of time, that short window. So it is going to be a huge change in terms of HR practice, HR procedure, what we need our managers to do, how we need our managers to focus, how we need our managers to make decisions, what our probation periods are going to look like. So again, it's going to be a massive change. And if we think about it, anybody that we are recruiting from July of next year, obviously, you know, once they hit that 6-month window, that 6-month period of employment, then of course they are going to have the right not to be unfairly dismissed. So again, big changes there. The other change, and this was this sort of late last minute throw-in curveball from the government, was around the removal of the statutory cap. Now, we know that the statutory cap is a cap of around about £118,000 or 52 weeks salary, whichever is the lower amount. And as we know, that rate goes up in April every year. Talking to you a little bit about that in a moment. And what was sort of thrown in was, as part of, you know, it appears as part of this deal between the government and the unions, and possibly business leaders, although they have said that they weren't particularly happy about this and couldn't support it, was the fact that that cap, that overall cap of £118,000 would be removed in its entirety. Now, that's going to have a massive impact in terms of claims, in terms of compensation. Yes, we have unlimited compensation potentially for discrimination claims. Yes, we have it with regards to certain claims, particularly around whistleblowing. But for unfair dismissal, it has always been one where, as advisors, you know, we are able to, as best we can, obviously, is to say, look, you know, you're potentially looking at an award of, you know, X amount of money. And that really helps either claimants in terms of focusing their mind on how much their claim is actually worth, and also focuses employers' minds around, you know, is this worth fighting? What's the commercial reality? Actually, what might compensation look like? When that cap is removed, and the government have said that they will commit to running an impact assessment or undertaking an impact assessment before the cap is removed. But what that will mean is that compensation claims will become much more complicated. So we will see much more complicated claims there, particularly around benefits, pensions. We will see claims going on for longer, you know, people claiming loss of earnings for a longer period of time. So it really is going to mean that we need to focus much more, yes, during probation, because that's going to be a key area, making these decisions within that period of time. But it's also going to be important when we think about dismissals more generally, is that regardless of, you know, whether you're making that dismissal, whether somebody's been with you for 1 year, 5 years, or 15 years, then will have the ability to claim greater compensation. So again, that's going to be something that employers will need to look at, particularly around training and policies and procedures, as well as contracts as well, thinking about our probation period. Other huge changes, obviously, around dismissal, re-engagement, fire and rehire, making sure that we've got that variation clause in the contract now. So we're looking at those restricted variations. And again, what that means if the employer wishes to make that restricted variation and then seeks to dismiss, that dismissal will be automatically unfair. So contracts of employment, making sure that we're aware what some of those limitations are going to be, not just if we want to make a restricted variation, but also if we want to make other changes to contracts of employment, because there are going to be some different tests that we need to be able to jump through. What you will see throughout once the bill does receive royal assent is that we've got this programme of change, increasing rights, enhanced scope, enhanced access to your workplaces for trade unions. And this will be a pattern from royal assent up until 2027. Fair Works Agency as well, a new body that's going to be established. We'll have to wait and see what the parameters are in terms of their their powers. One key thing was around that they would be able to bring claims even if the individual themselves did not wish to. So again, interesting there what that's going to look like. Collective redundancies as well, not just that percentage threshold test. So again, catching more redundancies, having that ability to check across the workforce how many redundancies are being made, but also the increase there in terms of protective award claims, going to be massive. Looking at our zero low and our agency workers as well, protections for them, not just in terms of being offered guaranteed working hours. You'll remember that this was another area that the House of Lords were not happy with. They only wanted guaranteed minimum hours to be offered if the worker requested it. But the government pushed back on that and said, no, we think it's the right thing to do. So again, it's going to be that almost hamster wheel of reviewing how much your workers have worked, offering them the new contract, and again, checking what they've worked and offering them the new contract. So yeah, bit of hamster wheel on that. And again, we don't know what that reference period is going to be. We think it might be 12 weeks, but again, watch this space. And obviously shift protections there as well. Family changes as well to be aware of, please. Again, changes to flexible working, enhanced protections for women who are pregnant, on maternity leave and returning from maternity leave. There's some consultation out on that at the moment. There's also some consultation out on introducing statutory bereavement leave. So again, please do go and look at that. Also changes there to equality laws around harassment. So this introduction of third-party harassment, not just for harassment, protected characteristic claims, but also for sexual harassment as well. So again, some big changes there. And remembering as well that preventative duty, the reasonable steps test is going to increase to all reasonable steps. And again, we need to think about whistleblowing and NDAs again with regards to sexual harassment. So again, they are the headlines. I'll be talking much more about them next year. We know we've got some changes that are coming in April. And again, we'll be talking a lot about this next year, but key things just to sort of have in your mind now: SSP, statutory sick pay changes. Again, this broadening out, increasing the eligibility, getting rid of the waiting days. And again, for those individuals that earn under the lower earnings limit, and again, getting rid of that restriction there. So they will be entitled to earn SSP up to 80% of what they actually earn. But again, subject always to that SSP cap. So SSP sick pay, managing sick pay, how we record that sick pay, how we monitor sickness absence, are we holding those return to work interviews? So again, all of that good practice stuff we need to be thinking about. Paternity leave, parental leave, again, day one rights, remembering that the right to earn statutory paternity pay, that earnings and that length of time that somebody is employed for, again, that's going to remain, but the actual ability to take the leave, again, is going to become a day one right. So again, thinking about that. And again, April, increasing the protective award claim. So again, need to be thinking about what that looks like in terms of collective redundancies. Time is tight when we think about it. Although, you know, the actual changes themselves to the threshold tests, again, that's going to come later on in the timetable. Consultations, lots and lots of consultations are going to be coming out. Again, something to really think about in terms of getting involved with those consultations, particularly where ones impact you and your business, which will probably be every single change, because it is huge. It really does impact everything that you do as an employer, as an HR function, the way you employ individuals, the way you engage with workers, the way you manage, the way you dismiss, the way you may, make changes to your workforce structures with regards to redundancies, how you manage your contracts of employment, your policies. It really is so impactful. And, that's why it is, it is a game changer. Overused phrase, but I think when we come to this, it really is. And just some dates for your diary, please. Again, we've got some manager training courses, some new courses coming out. This one is specifically for managers. I've been hearing a lot of feedback from employers, from HR teams, saying we need to have some manager training on this. So here it is. Can run it in-house, also going to be running it as open courses. So book your managers on, please. If you would like to come as an HR professional as well, you are more than welcome to. So it's a 2-hour course. March, Reading, and also going to be running it in London as well as in-person courses, but also that opportunity to join virtually. Again, small groups, please. If I get lots and lots of people who want to come and join the virtual course, we will run more. Okay, so please do let me know if you're interested in that. The invites will be coming out in the new year. But the aim of this is really to focus on the practical. Okay, what do managers need to be doing in the probation period? Why is it so important? Why do I keep banging on those of you who've listened to me previously about evidence? Why do we need evidence? How are we going to make those decisions? How are we going to set objectives? Why do we need to have review meetings? What you need to do as a manager. So if that's something that you think is going to be of interest to either yourselves or to your managers, or if you want to run it in-house, again, in person or virtually, please do let me know. The other course that I've got coming out is around how we manage those difficult conversations, how we have those courageous conversations, tackling tough conversations. Because a lot of what the ERB is about managers having the courage, having the skills, having the ability to be able to have those conversations with their teams and with their colleagues. So again, it's going to be a virtual course, this one, the 15th of April. It's a paid for course. It's an open course. So again, please do book on. Suitable not just for managers, but again for HR teams. And again, look out for additional dates because I think this one's going to be popular and we can run this course in-house as well. So really, really excited about that. Tackling tough conversations. Again, I think this is going to be one that we're going to need to be focusing on, not just in April, but I think further, and I'm probably going to put some more dates on as well in the autumn for this one. So again, something to think about, get in the diary, please. So some tips, again, I'm going to be focusing on this a lot, but I really do think we need to start getting on our 2026 agenda: contracts, policies, training, updates, awareness. We need to be thinking about auditing our workforces. We need to be thinking about, do we need to make some changes now before all these things happen? We do have time, but my goodness me, that time is going to tick, particularly when we get caught up in the day to day. So please, please, please think about what you could be doing now. Think about what you can outsource. Yeah, launching our rollout roadmap, how Door Clayton can help you and your organisation get prepared for all of this, whether that's through looking at your contracts, looking at your policies, coming and running some training and some update sessions for you, particularly around just to sort of flag, yeah, probation. I think that's going to be a really big area of focus. I think the HR masterclass, again, I'll be rolling that out in May and June next year, so look out for dates for that. But again, harassment and sexual harassment, really big areas there of focus. Thinking about it, October 2026, third party harassment, third party sexual harassment. We should be thinking about it now anyway, but it's going to become, as part of the Equality Act, and also thinking about those reasonable steps, moving to all reasonable steps. So audits, risk assessments, policies, training, awareness, staff surveys, all that fantastic stuff. We need to be doing more of it. So again, please do catch up with me. Right, let's get back to the main event, shall we? Because obviously, the ERB has been so huge, is so huge, and will continue to be, but we can't escape that actually 2025 was a pretty big year in itself. As we know, every year the rates change, don't they, for statutory pay? And again, we need to think about they're going to change for next year as well. But just to sort of flag compensation for unfair dismissal, goodness me, we're going to miss, aren't we, these sort of weird and wonderful numbers that we have to remember, because as I've said, the plan is to remove not just the 52 weeks, but also just to flag again, not just the 52 weeks, it's also going to be that overall cap. So no longer am I and my fellow employment lawyers going to have to try and remember these really strange combinations of numbers. So 118,223, there will be a change next year, there will have to be, and obviously then that will increase, as we know, from 1st of January, when we will have no numbers to remember. So just to have a think about that. Also, just to flag there, a week's pay. It is, again, subject to any late additions or any changes during consultation, but it's looking like that an individual who does have less than a year's service, who brings an unfair dismissal claim, it's looking likely that they won't have a claim for a basic award. It only applies after 1 year's service, but again, we'll have to think about that. And obviously, as we know, statutory redundancy pay will kick in after 2 years. So again, watch this space. But I'm not expecting any changes. But again, who knows what the government might do. But, just have that week's pay on your radar. And of course, that will change again. Just to say at the moment, we don't know what a week's pay is going to be from April 2026, nor do we know what the last ever compensation cap will be for unfair dismissal. Again, we will know that later on next year. Obviously, sort of statutory rates there. Sneak peek, sneak preview at next year's rates. Obviously, I'm not expecting anybody to sort of remember these. I will be talking about them lots more next year and bringing out our rates card again. So again, we'll be sending that out with all of this on. But just a couple of things there just to have a think about. I flagged SSP because obviously SSP, potential there for it to be payable. Obviously, we're going to be getting rid of those waiting days, so payable from the first day of sickness absence. And also they're thinking about the fact that it is going to apply to a wider category of individual, those low hours employees who earn currently under the lower earnings limit. So the lower earnings limit for statutory sick pay will go. And those individuals will be able to earn up to 80% of their average earnings, again, subject to that cap. So lots of administrative work to be done, lots of extra payroll work to be done, lots of extra sickness, absence, monitoring work, etc., to be done. Training, awareness, absence management, we've got the tools at our disposal. So let's use them and let's talk about them and let's train to them as well. So again, some things to think about there. National living wage as well, making sure, of course, that we are compliant with those national minimum and national living wage rates as well. And as we know, SMP, SAP, neonatal care leave, statutory bereavement, parental bereavement leave, paternity pay as well. Again, that's going up to £194.32p a week from April. So again, things to watch and things to have in our, on our to-do list. April 2025, again, we also saw that introduction, didn't we, of neonatal care leave. So for those of you who have not already looked at your family leave policies, certainly next year is the time to do that, particularly when we think about April and the changes there to both paternity leave and parental leave. It's also a really good opportunity to look at whether we cover off neonatal care leave as well. I should also say that there's going to be some changes there to paternity and shared parental leave, that anomaly there, which precludes somebody from taking paternity leave if you've taken shared parental leave. So some anomalies there to look at in terms of your policies. So again, it's a really good time if you haven't already got your neonatal care leave policies sorted. Again, let's have a look and have a refresh. Also think about those wider implications, particularly with those individuals, particularly mothers who will be taking their neonatal care leave and tagging that on to the end of their maternity leave. That's their tier 2 leave. So thinking there about notification arrangements, but also there the potential for somebody to have, an additional, up to an additional 12 weeks off at the end of, obviously, their neonatal care, their maternity leave. So again, we just need to think about what that looks like. And also thinking about, if we've got work, if we're covering work for other people, again, thinking about what that looks like from a practical perspective. So, raising awareness, making sure that we've got, our policies up to date. So neonatal care leave was something that we looked out for in April. Also, just to have a think about, thank you very much. Just looking at the questions, I'll have a look at those later, please. Now, just looking at obviously other changes that happened this year for our larger, clients as well, for our larger companies, particularly those in the financial services sector. Again, the new corporate criminal offence, where larger organisations will be held to account if they profit from fraud committed by their employees or agents in the absence of any preventative procedures in place. Where have we heard about the preventative duties? Again, of course, sexual harassment, and again, third-party harassment, which is coming in. So again, this idea of preventative duties, taking those steps before things happen. Again, that changing mindset, isn't it? From, this won't happen here to this can't happen here. So again, some really, really good things to be thinking about. Get in touch there if we can help with that. Also just flagging for, again, those regulated employers and clients amongst you, looking for some FCA guidance as well, changes to FCA non-financial misconduct rules as well. So looking forward to those coming out. I'm sure we all are from May next year. So again, look out for that. The other change to think about is around NDAs, settlement agreements. So as I've said, there's going to be some changes to settlement agreements under the Employment Rights Bill, particularly around preventing individuals from raising concerns, raising allegations around sexual harassment. Again, making sure that they are not precluded within a settlement agreement. We saw some changes in this year in October around settlement agreements, NDAs, seeking to prevent somebody who is either a victim or perceives himself to be a victim, raising allegations, again, of issues, criminal offences, making disclosures to a lawyer, to the police, or to a regulator about relevant conduct. So again, we're seeing, aren't we, that there are lots of restrictions around what employers can and cannot use settlement agreements and NDAs for. So again, if you've got those NDAs, if you've got those settlement agreements, really getting those looked at as well and keeping those under review, because I think there are going to be more changes when we think about the sexual harassment changes that are going to be happening next year with regards to whistleblowing and with regards to settlement agreements. So again, ADAs, NDAs, settlement agreements, always one to watch. Who would have thought that we would have had December changes as well, a new one thrown in by the government? But actually, some really big changes that happened in December. The first one was regarding digital HR1 forms. Now, digital HR1 forms have been around, they're not new, but from the 1st of December, they are now mandatory. So, you can obviously frame your old paper copies and keep those on the wall as a keepsake, but digital is the way forward. One top tip is around the fact that once you submit that digital form, you can't get it back. So you need to make sure that you've got a screenshot or you've got a copy of it somewhere, because obviously that forms part of your collective consultation information. And also you need to say as part of the HR1 process that you're going to, and you understand your consultation obligations, and obviously with regards to staff reps or obviously trade union representatives. There is a new redundancy reason which has been added to the form, which is change in supply chain or loss of supply chain contract. So again, HR1 forms collective redundancies. Not only have we got changes next year in terms of protective award claims, but again, really, really thinking about the digital form as well. Also, another curveball which was thrown in, and one which again is going to make a huge change, is around ACAS early conciliation. So that was 6 weeks, is now increasing to 12 weeks. And of course, that's going to mean that that period of time, that length of time that an individual has to bring a claim is obviously going to be extended. Let's then think about the changes under the Employment Rights Bill in terms of increasing the length of time an individual has to bring an employment tribunal claim. That's going to increase from 3 months to 6 months. When that happens, and then when we have a longer conciliation period, that's going to have a huge impact on things like witnesses, evidence, settlement, getting ourselves organised in terms of, it's not just sort of crossing our fingers and hope we don't get a claim, for 3 months. It's, now going to be 6 months. So again, it's going to have an impact too on retention periods, how long we're keeping data for. So ACAS early conciliation period has a huge impact now. 12 weeks is a long time. Yes, potentially it's a good thing, as it means that, it might mean that we actually get a call from ACAS, and it might mean that we can, actually reach a settlement before the claim can go to the employment tribunal. So a really good thing, particularly if you're on the cusp of, reaching an agreement. But, the tribunal system is really busy, incredibly busy. So again, we'll have to wait and see how helpful the longer conciliation period is going to be. But again, let's have an eye on next year and future years when we've got that extension to the time period to bring an employment tribunal claim. 3 to 6 months, big change there. Now, I'm just going to touch very briefly on the immigration changes. I just want to say this is completely high level. I am not an immigration lawyer, but I do think that we can't talk about 2025 without mentioning some of the immigration changes. Also, we have to remember that, like employment law, immigration law is incredibly nuanced, very, very fact specific. And also, we can't think about immigration law without thinking about employment law. So again, please take advice, but I do think that we need to have our eyes on both issues, and again, moving forward into 2026 as well. So a big year. July was a big month for immigration, although speaking to my immigration colleagues, it seems that every month is a big month for immigration law. But we saw, didn't we, the skills level threshold increase, we saw the salary threshold increase. So again, the potential there for over 100 jobs to be taken off of the skills threshold, skills worker visas. And again, think about this, yes, there are some jobs that you are no longer going to be able to get sponsorship for, but what about if somebody already has sponsorship? So again, really thinking about that employment law and immigration law aspect. So again, some key changes there around the increasing of the skills threshold. And then we saw the salary threshold as well. Again, there are some caveats to this. There are some exemptions to this. So again, not everything is as we say, you need to take advice. But again, that increasing of the salary, what is that going to mean? When we think about people who are maybe in a job now with a visa, what's that going to mean? At the end of that process. So again, some real changes there in terms of salary thresholds. But again, always take advice on this. Also, we saw the introduction there of that temporary shortage list. And again, we are seeing the phasing out, aren't we? The gradual removal there of the care worker sponsorship route. So again, some big changes and some huge changes to come next year as well. I'm going to flag a couple of issues to you. Settled status, leave to remain, changes around that, and I'll be talking with my one of my immigration colleagues in January on January's webinar about that, because again, there's some big things to think about. There's also some changes to travelers, ability people to travel in and out of the country as well. Again, so thinking about that, visa requirements. Also, another big change, right to work checks. That the proposal there to extend that not just to employees, but also to a wider category of individuals. Again, thinking about subcontractors, agency workers, again, huge change there that we need to be thinking about. So again, one to watch. So immigration is, again, lots to think about there. And do please, join me in January or reach out if we can help you with any of those changes. HR support, I definitely want to flag right to work checks. Again, right to work check audits, training, visa advice, sponsorship, and again, looking at your existing workforce profile and your existing visas at the moment. And remember just how important it is to keep hold of that sponsorship license as well. So again, please do reach out to me or my colleagues if we can help. Deep breaths. 2025 has been a big year. There's been lots of uncertainty. As I said, I know there is much to do. I know it feels like we've got that mountain to climb, but I do think just having that certainty around the fact that the bill has passed, it will get royal assent, whether that's today, tomorrow, or in January, but it's passed. We know that we've got to really think about that 6-month window, looking at our probationary periods, looking at how we manage those probation periods, but also with the removal of the cap for unfair dismissal compensation in its entirety. Again, what's that going to mean in terms of settlement, in terms of claims, in terms of how we manage those exits, particularly senior exits? And again, process, making sure that we've got that training and that awareness, not just in terms of performance management or probation, but also around absence management in terms of conduct as well. So some really big things to be thinking about there. Also thinking about engagement with our stakeholders. We talk a lot, don't we, about, HR need to do this, HR, heads up. But I think we just need to be thinking about it's not just an HR thing. We need to be thinking about how we can engage with our boards, how we can engage with our managers, and again, thinking about bringing them on board, because this is an opportunity to think about how we do things, thinking about our culture, thinking about who we are, embedding that positive performance management as well. So again, we need to be really kind of engaging. This is not just an HR thing. We need to make sure we've got clear, updated and clearly communicated policies. There's no point having a policy if people don't know about it. Employee 101 argument, I didn't know. Well, let's change that. And again, this is all about keeping you up to date. So if you're not already signed up for our updates, if you're not already signed up for our webinars, then please do that. And again, staying ahead of the curve, and again, making sure that we've got that knowledge, got that information is going to be key. We are here to help you. Please, please, please outsource. And again, please do join one of the training courses that we've got listed, or again, reach out for in-house training as well. That would be absolutely fantastic, and would love to hear more from you. Just on the questions again, thank you so much. Yeah, the timeline, once that's updated, again, get that sent out to you, because then I think that's going to be your kind of roadmap to the changes. Samantha, thank you for your question there about immigration. I will pass that to my immigration colleagues as well. So we will come back to you on that. So that really does leave me just to say, again, sign up for January's webinar. Really looking forward to seeing you for that. And also, as ever, have a fantastic break. Look forward to seeing all of you either at a training course or at one of our webinars and in-person sessions that will be coming up next year. Have a wonderful Christmas. I'm going to tell you to please, please, please have a restful new year, because we have much to do together in 2026. I'm looking forward to it, and I hope you are too. And remember the mantra, in all challenge comes opportunity. So I look very much forward to seeing you all next year. Thank you very much, and speak to you soon.